All right, everybody, we are back for our last post-loss obligation examinations under oath, but let's do a quick recap. Remember, these are not all the post-loss obligations under the policy. There's just 5 of them that we're discussing today because I think they're the ones that are the most important for contractors especially to know and to be familiar with because they're the ones that come up over and over and over and over. Secondly, commercial claims. You may want to look at the policy because commercial policies have completely different post-loss obligations than residential claims. Also, jurisdictionally, different parts of the country. I don't know what state you're in because you're on the other end of the camera, right? So I'm not sure. So you might want to check with your local council to make sure that you are complying with your local laws and your state laws in order to make sure that these post-loss obligations are met. Why? Because they're duties under the insurance policy that the policyholder has. In other words, they're requirements, they're obligations. In order for them to get paid, indemnified, they have to meet these post-loss obligations. So let's jump right into our last and final one, examinations under oath. So what is an examination under oath? Now, an examination, all right, under oath is a pre-suit deposition. That's all it is. It's where the other side of the contract has an opportunity to take sworn testimony of the other side, right? Examinations under oath are very different from a deposition in that when you have an examination under oath, the opposing counsel cannot object. There's no objections. And when I have my clients in examination under oath, I literally have to just sit there. But now I don't, all right? But that's me. So I interject a lot and I kind of make sure that the information is clear. And if it's not clear, I'll say something. And a lot of times I'll get pushback from opposing counsel that says, look, you're interfering with this post-loss obligation. And my answer to that is always the same. Your job today, what you're here for, is to investigate the claim. So do you want accurate information or not? That's what I tell them. And a lot of times they'll let me interject and help the client. But I don't suggest that you do that if you're doing these on your own or if you're there on behalf of a policyholder. Because if the failure to comply with an examination under oath is fatal. It's fatal to indemnification, all right? So it's nothing more than sworn testimony that's pre-suit of the policyholder. Why do an examination under oath? Well, an examination under oath is there as an investigation tool of the carrier. It's there so that they can get this sworn testimony so that the story doesn't change down the line. And a lot of times they'll take examinations under oath if they suspect fraud, or if they suspect that the claim is not legitimate, or if they suspect that the policyholder is claiming damages that they really shouldn't be claiming. In those instances, they'll put their testimony under oath in order to preserve that testimony for later on down the road in case the story switches or changes. Who has to sit for an examination under oath? Well, we already know that the policyholder or holders has to sit for an examination under oath, right? That's the requirement. But what about the public adjuster? What about the contractor? Now, this is a very hot topic and it varies from jurisdiction to jurisdiction. Some jurisdictions say that if the policy requires the public adjuster or the contractor to sit for the examination under oath, then the public adjuster and the contractor must sit for the examination under oath. Other jurisdictions say no, not necessarily, right? Because this is imposing a contractual duty between the policyholder and the carrier onto a third party. So you do not have to sit. But let me ask you this question, and here's what I always tell public adjusters when they call me and say, hey, do I have to sit for this examination under oath? My answer to them is, why would you not want to? You have all the information. You're the one that's skilled to present the claim in the best light for the carrier. You're the one that can explain the damages and explain why it costs so much and explain how you come to that price. I love it when public adjusters sit for examinations under oath when I have a case, because it's my opportunity to resolve the case early on quickly, because you as a public adjuster have that information. Contractors, I think it's a dangerous, slippery slope for you to sit for examinations under oath, because in many instances they will ask you questions that could lead to unlicensed practice of public adjusting, and you really don't want that. All right, you don't want to put yourself in that position. If you are a contractor and you get asked to sit for an examination under oath and you do sit for it, you need to make sure that your testimony is limited to what you do in your profession. It should be limited to the damages that you see, what you think caused those damages, and then what it's going to take to replace and put the policyholder back into its pre-loss condition. Nothing more. You shouldn't talk about policy, you shouldn't talk about coverage, you shouldn't talk about nothing else. You should only talk about those three things, which is your lane, right? Stay in your lane, and use the examination under oath as an opportunity to explain it to the carrier. Why? Because if they still fail to pay afterwards, after you've done all that, that could lead, in some jurisdictions, not every, could lead to a bad faith lawsuit later on. Because why? Because the carrier has now failed to pay when it became reasonably clear that they could have and should have paid the claim, right? Why? Because they got all that information up front. So, always, no matter who you are, if you're the policyholder, if you are the public adjuster, or if you're a contractor, you should have your own attorney. Never ever do examinations under oath without a lawyer helping you and being present. Now, in my office, we spend as much as 2 days prepping for an examination under oath before we even get to the examination under oath. Why? Because we want to make sure that when we present the claim to the carrier, that we're presenting, number one, accurate information. Secondly, we want to make sure that we're giving them complete information. So if they ask us a question, we want to be able to answer that question, and we want to be able to provide them with the information. Why? Because what's our goal? What is our goal? Indemnification of the policyholder, right? And if we can present that claim up front and present it accurately and completely, we have a better chance of getting a check than we do taking it to litigation or fighting it out for months on end. Examinations under oath, however, are the carrier's way of saying, we don't think something's right with this claim, right? Our job at the examination under oath is to show them that you're wrong. Everything is correct with this claim, and that this claim should be paid. Now, what information is the carrier allowed to ask? That is a loaded question, and it's jurisdictional as well. I try to limit examinations under oath to the claim itself and to nothing else. So I try not to let the carrier get all off into what happened 10 years ago, or into any other insurance claims, or into 20 years of financial records and just craziness that they try to get you into. And if you see these letters that they send to you, sometimes they're 8, 9, 10-page letters of documents that they want to request, right? So I try to negotiate that out with opposing counsel and say, look, no, do you really need this? This is a roof claim from a hurricane. Come on, seriously? Or this is a water loss from a toilet. Do you really need to know what happened in 1992? No. And so examinations under oath can be a very powerful tool for the insurance company, but remember, it can also be a very powerful tool for the policyholder. And we need to start thinking about it that way and not be scared of examinations under oath. We need to embrace them, and then we need to approach them in a manner to where we use the examination under oath to present our side, so that the policyholder, who's your customer, your client, my client, can get paid, because that's what we're really all doing, indemnification of the policyholder. Listen, I want to thank you for watching these 6 segments on post-loss obligations. I've enjoyed bringing them to you, and I just want to do a quick recap of what they are, right? Post-loss obligations obligations under the policy that the policyholder has, and they must be met. We only talked about 5 of them, and we only talked about 5 because those are the ones that come up the most that I wanted you to be able to know about. So 1, prompt notice. 2, mitigation, but reasonable mitigation, right? Not unreasonable mitigation. 3rd one, cooperate and show the damaged property. 4th one, proofs of loss, and now examinations under oath. Listen, I'm Stephen Bush with the Bush Law Group. I hope you enjoyed this, and I hope you have a great year.